It's 11:30 on a Wednesday evening, and you're in a small conference room with your two lawyers. Everyone is exhausted, a bit on edge, and you're finding it a bit difficult to focus your mind. Your thoughts are racing. Have we considered all the important points? Am I accepting too little? Asking for too much? What are the tax implications? Am I doing the right thing for my family? Litigation is a difficult situation at best. At worst, it's like a mini war. If you want to learn about Florida probate and trust litigation, stay tuned. Hi, my name is Brian Duffy, and I'm a Florida lawyer. Welcome to DuffLaw Digital. Today I'm here with Jonathan Burns. He's of counsel with the Duffy Law Firm, and he assists us on our probate and trust litigation. Welcome, Jonathan.
Thank you, Brian. It's great to be here. Probate and trust litigation is a fascinating area of the law. It is one of my favorite areas of the law.
By the time you find yourself at settlement, as we opened this morning, hopefully you'll run through all the critical questions with your attorneys and other advisors, and you'll already know what your BATNA is. Today we'll briefly discuss what to expect in a Florida probate and trust litigation matter and how they evolve, generally speaking, and just exactly what is a BATNA. Stay tuned and you'll find out. Where Mark Zuckerberg was being deposed and, by the cameras, and he was, arguing with the attorneys and all those kinds of things. And, movies are wonderful, but the truth of the matter is these depositions they're a very important part of this process. And not only are we focused on what the other party is going to say and what they can or cannot prove in their case, we're also focusing and preparing our client for their deposition. So Jonathan and I will work with the client to make sure that they understand, exactly, what is the best way for them to put forward the facts that work mostly, in their favor without doing anything improper or withholding any evidence that would be required under the procedural rules. But again, preparation you can't overemphasize the need to prepare for the depositions of your clients as well as the other side.
In all areas of litigation throughout my career for their deposition, and I can tell you it's a lot less dramatic at a regular deposition than it was in The Social Network or really any other movie. It's the mundane details. It's the information in a particular matter that could be something that costs $50 that really matters when it comes to probate litigation, not $50 billion like it was in The Social Network. So that's really what we're focused on, the details, the things that maybe are not showing up in a client's brain as being important, but we have to explain to them why it matters in the sense of their lawsuit.
Sure. And, we mentioned earlier here in the discovery phase, we talked a little bit about depositions, we talked a little bit about interrogatories, but we also have the power of subpoena. And in a case we had a couple years ago, through subpoenas, we were able to get bank records. And again, like Jonathan's pointing out, a lot of it is tedious, a lot of it is not glamorous, but that's really where you win or lose lawsuits sometimes. And in the course of reviewing these bank records, and they were voluminous, we uncovered a situation where a trustee had made a transfer out of a trust account that was improper. And it actually was done over a year before the client came to us with their concerns. But by the use of that information, we were able to discover an improper act by the trustee, who is a fiduciary, and therefore it was a breach of fiduciary duty, which again, when we talk about motions, we're going to talk about the posture of the case and about using motions and to posture and strategize within the case procedurally to either strengthen our side or weaken our opponent's side or both.
Absolutely.
So let's talk a little bit, we'll move on to motions, and we'll talk a little bit about how we use motions in the practice. There was another case where we had a personal representative or trustee, and our client was a beneficiary. We wanted to do what we could to bring about a resolution and a settlement, if possible, before trial. And one of the things that the fiduciary wanted to do was she was trying to use leverage against our client by filing a claim against the estate, where she was going to extract money out of the estate to pay this claim. But unfortunately for her, the claim was late. And because of the motions and because of procedural practice, we were able to block that claim. So it was a pretty big deal. that, among several other factors, were really keys in that case that helped us to settle it before trial.
Absolutely, and it's the attention to the details. It's the ability to block a late claim that really allows us and separates us from the other law firms out there, to properly represent our clients and get them the positive results that they want and the just results under the law.
Right. So motions practice is important, and this is really sort of a procedural, kind of in the weeds, area. But this is an area that you have a lot of experience in from working in litigation over many years.
Absolutely, and motion practice can be very contentious. My theory on how to practice law and how to litigate is that I file my motions. If the other side agrees, great. If they don't, then we just set a hearing. I'm not going to scream and yell on the phone. I will rush to the courthouse and let the judge make the decision, because that's how we handle litigation. It's not a back and forth type of thing. It's whatever the law says is what we're entitled to.
You raised a great point in the start of that that you were just talking about, which is sometimes, and going back to what we were saying earlier, that these can be very emotional situations. Sometimes our clients will sort of press us as attorneys, or maybe even the clients of the on the other side will press their attorneys to fight with as much sort of anger and emotion as they're feeling. In other words, sometimes they want to sort of punish the other side, and they want to do that by being as difficult as possible in the litigation process. I think what we found over the years is, number one, as I said earlier, the litigation community, at least in South Florida, where we practice a lot, is a small community. We know the other attorneys, and the other attorneys know us, generally speaking. We've practiced against them, and we will again in the future. Our philosophy is, we don't need to bang on the desk, and we don't need to raise our voice and yell and scream, and we don't need to accuse people of lying or cheating or anything else. What we need to do is we need to get our information, get our facts, get everything marshaled in a way that we can present it to the court in a way that will convince the court, and use that leverage to achieve for our clients what their real goal is, which is to win the case and to do it as effectively, cost effectively, and efficiently as possible.
Absolutely, and there's a level of credibility that litigating the correct way and not coming off as someone who's screaming and yelling at judges, lawyers, and clients. We like the courthouse. We are in the courthouse on a weekly basis, several times a week, and the judges know that. And the judges know how to litigate, know how to try cases. The judges are aware of the trial lawyers who are in court all the time, and the judges are also aware of the lawyers who don't know how to behave. And that is an integral part of the process. We will advise our clients on the best way to handle the case, and they typically let us handle that because they know that we've been in the battlefield for a long time.
Absolutely. I've always found over the years that when another attorney raises his voice or becomes particularly, hyper ventilating over some issue, it's usually because they didn't prepare, they were surprised, and they don't like the facts that we're laying out for the court, or in the deposition, or in whatever phase of the litigation we're in.
Absolutely, or they just don't know the law.
Right. Okay, so now we talked about motion practice, and we talked about strengthening our case and positioning the case and all that, and looking for weaknesses in the other case. Now let's talk about settlement and mediation. So first of all, mediation. Why don't you just mention for our viewers, why are we going to mediation? Why are we talking about that?
Mediation is a very valuable tool in the litigation process. One is required by law here in Florida before you can get to trial, that you have to have a mediation. And what's a mediation? A mediation is when all the parties in a case sit down and they have hopefully meaningful settlement discussions. The vast majority of mediations are successful. Sometimes mediations are short, sometimes they last 10, 15 hours if you're really getting something done. Typically it's something in the middle. And mediation is an opportunity for both sides to sit down in the same room at the outset and discuss their case. And it's a valuable tool because the clients for both parties are there with the lawyers as well as a mediator, and they hear what the other side's arguments are. And then you have a neutral third party in the form of a mediator who doesn't have any legal power. It's his or her job to sit down and try to help a case resolve. and he or she goes back and forth between the two rooms, and hopefully at some point there's a resolution. But it's a valuable tool for our clients and for the clients on the other side to hear what's going on in the case and exactly what their chances are at trial, because they are typically not at every deposition or hearing, and they can hear a third party in the form of the mediator tell them what he or she thinks is going to be the ultimate outcome in their case.
Yeah. To me, it makes perfect sense, too. I mean, I really see this as something that's extremely useful, something that's necessary. As you mentioned, it's required under law anyway. But I see it as an opportunity to further advance our client's position. Look, there's no downside to it. Either we're going to end up with a settlement, which is, if we're going to settle, it's going to be, by definition, the client's accepting the settlement offer, or we're going to go to trial. But the way that we look at it and the way we've worked together on these things is we're going to use every minute in preparation and in the course of the mediation as it plays out to, again, probe our strengths and weaknesses of our case, probe the strengths and weaknesses of our opponent's case, learn everything we can. There's been times when we've been in a mediation or a settlement where we'll get some information and, confidentially we'll go back to our client and say, this isn't good news. We did not know until today that they have a witness that says that, some competency, demonstration was made by the decedent prior to his signing the will or the trust or something like that. So just as a quick recap for people that don't have any experience in, probate and trust litigation, in mediation, both sides will choose a mediator. The mediator will be an independent third party. Oftentimes this may be a retired judge, but sometimes it might be an attorney who has a lot of experience in this area. And that mediator will listen to both sides. Generally, you meet in a neutral location. Sometimes it's a mediation area, or it could be the mediator's office, or it could be either side's attorney's offices. And the mediator will meet with both sides. He will listen respectfully, he or she will listen respectfully to both sides. And their job is to try and bring the parties together in a way that is appropriate. In other words, if one party has a weakness to their case, legally speaking, they don't really have much of a chance to establish this based on the information that they're presenting to the mediator. The mediator will tell us that straightforward. You guys are going to have a hard time convincing the judge that this was a breach of duty because, and whatever that is. And then the mediator will go into the meeting, generally with the other party, and we'll say the same thing. Maybe, they're making some kind of a claim that, our client did something improper and that's why, we are where we are. And they may tell them the same thing. So they'll sort of point out the strengths and weaknesses. They'll come back over to us and they'll say, guys, the other side is telling me this, and according to what I see in their mediation brief, there's documentation showing that that is the extent of the value of the trust or whatever it is. And so, this will all provide us with good information. At some point in time, we're going to need to sit down with our client and we're going to need to discuss their BATNA.